Fine. How can you relate the FR, DPSP and FD? ठीक है? Lot of questions can be asked on this idea also. ठीक है? Relationship simple है. Justiciable. Citizen centric. ये citizen centric नहीं है ये तो. This can be for persons also, no? See, justiciable, non-justiciable, non-justiciable. Fine. And so enforceable through law, enforceable through law, enforceable through law, constitution, court, judiciary, everything. ठीक है. Review किसका हो सकता है? इसका. When we say review, review सबका हो सकता है. See, but when we say कि judicial review of legislature and executive, right, with respect to violation of fundamental right, तो ये इसमें हो सकता है. Judicial review इसका भी हो सकता है, इसका भी हो सकता है. Means when you make a law, right, then you can go to the court. If the law is not implemented, you can go to the court, right? But the requirement is that there should be a law. Fundamental right के लिए requirement नहीं है कि there should be a law. Fine. Like for example, Article 17, untouchability, right? So Protection of Civil Rights Act, है ना भाई? SC/ST Act है. तो वो act हो या ना हो, ये right protected. Act ना हो तो ये protected नहीं है. Fine. You cannot say कि भाई I want government to implement this policy because it is mentioned there. No. Right? When the government will to make the policy and make a law to implement that policy, then you can go to the court. You see, this law has been made, but it has not been implemented. Fine. Then also, it's not necessary that court will give you the solution. It may say that okay, wait for the government to take the measures. Right? तो ये आप directly नहीं करा सकते. Though it is equally important as this. Fine, because this is for collective interest. This is for individual interest. ठीक है, ये public utility या public welfare या public के लिए जो collective benefit है, उसके लिए create होता है. ठीक है, ये फंडामेंटल ड्यूटी इज बेसिकली, ये तो ऑब्वियसली इट वाज नॉट देयर. फाइन. ये कब ऐड हुआ? 42nd कॉन्स्टिट्यूशनल अमेंडमेंट क्यों बनाया? सी, देयर वाज अ कमिटी नोन एज स्वर्ण सिंह. Its recommendations were not accepted actually. Fine, but still it had recommended for 8 fundamental duties. 42nd, 1976, they were added, right? Obviously, you can imagine why they would be added. They were added to create obligations on citizens. ठीक है, क्यों किया गया था? इसलिए किया था कि इमरजेंसी के बीच में, right? So इन्होंने 8 बोला था, but they did 10. 11th duty is the latest duty, as you know, 51A(k). ड्यूटी का कॉन्सेप्ट कहां से आया? कम्युनिज्म. Fine. Are they for welfare? Yes, they are also for welfare. Fine. But here, the responsibility, क्योंकि democracy में it is the assumption that people also need to participate. ठीक है. अब जैसे डॉक्ट्रिन हमने पढ़ा, डॉक्ट्रिन ऑफ लैचेस, क्या है? Correct. Right. So this in no way violates this Article 32. Right. That Supreme Court is obligated to give you the justice or protect your fundamental right. So it does not violate it. Why? Because you also have a responsibility towards your own rights. Right. That is why we use the word. The Article 32 or 226 talk about prerogative writs. Prerogative writs. What is prerogative writs? They are coming from UK, right? Prerogative writs का मतलब क्या है? ये privileged है. Fine, you are treated something very important, and that is why you are given the remedy. So these are privileged writs, but obviously for that purpose you should also know that your right has been violated. If you do not have that awareness that your right is violated, then even courts can't do anything, right? Even though PIL can be filed, suo motu cases can be taken up, but still it is a person who should be able to understand that his right has been violated. Okay. So ये rates जो है prerogative है, privileged है और progressive. Fine. Okay. So these two are complementary to each other, right? This is a supplementary aspect. Why? Because duties should not be made obligatory like rights. Rights can be made obligatory on the state that give me right, but state cannot make the duty obligatory on the citizen. It will violate the democratic principle. इसलिए duties को हम justiciable नहीं बनाते या enforceable नहीं बनाते. Why? It will violate the freedom. Everybody is not in a position to follow the duty. Fine. Everybody may not be in a social situation to follow every duty. In the name of duty, the government can restrict and control the individual rights. So if DPSP and FD become important, right, by matter of policy, if the government wants to implement them, then also they cannot violate the fundamental right. That means in case of DPSP or FD or FR, which will prevail? FR will prevail. हमेशा fundamental electoral bonds का example है, right? So वो हमेशा prevail करेगा fundamental right. Fine. So you write few questions on this idea, then let's see. Right to information, electoral bond एक matter of policy है ना, तो policy को override किया fundamental right. That is what court has said. No? It violates 19 and 14. So it has made it unconstitutional. It was a matter of policy. Representation of People's Act. तो fundamental duty क्या है? Fundamental duty है ना भाई अपना democracy को protect करना, participate करना, ये करना, वो करना. See, in that sense, the FR Representation of People Act can be protected. That okay, it has been created as an obligation on the citizen so that they participate in the electoral process properly. Political parties can function properly. Democracy can function effectively. तो उसमें सिर्फ गवर्नमेंट का रोल नहीं है, लोगों की ड्यूटी है, पॉलिटिकल पार्टीज की भी ड्यूटी है. तो रिप्रेजेंटेशन ऑफ पीपल्स एक्ट उस सेंस में एनफोर्स होता है, राइट? बट आरपीए और उसके जो प्रोविजंस हैं, इन दैट प्रोविजन द मॉडिफिकेशन वाज डन टू अकोमोडेट द इलेक्टोरल बॉन्ड, राइट? तो हमने क्या किया, गवर्नमेंट सुप्रीम कोर्ट ने उसको भी इलेक्टोरल बॉन्ड को भी अनकॉन्स्टिट्यूशनल बोला, और जो प्रोविजनल चेंज हुआ रिप्रेजेंटेशन ऑफ पीपल्स एक्ट, इनकम टैक्स एक्ट, चार्टर्ड अकाउंटेंट्स एक्ट, जो भी चेंजेस हुए, राइट, उसको भी उसने अनकॉन्स्टिट्यूशनल बोल दिया. So in case or in matter of policy, what will prevail is fundamental right. Policy was created for larger public interest, transparency, accountability, whatever, right? But in spite of that, the fundamental right prevailed. They could have used it, but the entire scheme of the electoral bond seemed to be unconstitutional. How can they eliminate one part of that? Fine. So they have, obviously, the doctrine of severability will be implemented, one part will be. Eclipse कैसे? Your individual information is not being disclosed, no? Somewhere you have to balance. That is called doctrine of harmonious construction. No, but see, it is not like that. Any information can be taken as private information. So how to balance the DPSP with the fundamental right? Fine. So पहले कोर्ट ने बोला कि भाई fundamental rights cannot be amended. Fine. Then court said fundamental rights of privacy over everything. Right. Then later on गोलकनाथ case, कोर्ट ने एक्सेप्ट किया कि भाई अमेंड हो सकता है. फाइन. लेकिन जो है नहीं अमेंड हो सकता है, बट मेरे डीपीएसपी को भी प्रोमिनेंस मिलेगा विथ रिस्पेक्ट टू एफआर. फाइन. सो दे एक्सेप्टेड इट, बट ओनली फॉर सम डीपीएसपी. देन बेसिक स्ट्रक्चर दे रीमॉडिफाइड देयर व्यू. Fine. A.K. Gopalan का view सब मीडिया modify किया कि that no, the fundamental rights can be amended to any extent by the constitution. That is the judgment of Keshwan and Bharti. That there is no limit to the amending power of the parliament of the fundamental right except basic structure. So Keshwan and Bharti case basically expands justifies the power of the parliament to amend the constitution, because when that Golaknath judgment comes, right, as a reaction to that, the 24th Amendment Act 1971 and 25th Amendment Act 1971 was enacted, right, so that it can restrict the power of the court. इसलिए वो reaction आया, right? केशवानंद भारती भी reaction ही था of the government's reaction, right? So केशवानंद भारती का reaction था 42nd Amendment, right? फिर उसका reaction आया मिनर्वा मिल्स केस, मेनका गांधी केस and likewise. So that era from 1967 to 1980 वो पूरा जुडिशियल और एग्जीक्यूटिव का या जुडिशियल लेजिस्लेचर एग्जीक्यूटिव का कॉन्फ्लिक्ट कर रहा है पूरा. Okay, and that is where the judge's case comes, where the collegium system, the power of the executive is taken away by the judiciary itself. First judge's case, second judge's case, now third judge's case, and likewise. So they took away the power of appointment to themselves. So that is a reaction by the court. Right? So when you say judicial activism, yes, judicial activism somewhere entered into judicial encroachment. PIL is a direct encroachment. Like, आप constitution को the way you want, you cannot interpret, no? Because there is nobody else who can interpret. So you have interpreted the way you want. Right? A lot of things the courts have done, right? The way they want, they have interpreted. Even in the Babri Masjid case, there is no judgment, right? It's a solution. Pacification है ना वो problem का, right? 370 का भी judgment pacification है problem का, right? जैसे electoral bond का judgment एक clear judgment है, but 370 का भी नहीं है, right? बाबरी मस्जिद का भी नहीं है, और भी बहुत सारे ऐसे 377 पे नहीं है. So many areas you will not see that there is a judgment. So even courts play a diplomatic role, which is not acceptable on part of the court. Court को diplomatic नहीं होना चाहिए. As simple as that. Fine. So harmonious construction says कि भाई you have to balance, right? For example, that 39B, sorry, C. So harmonious construction says कि भाई you have to create a mechanism, right? आपको एक midway निकालना पड़ेगा. We call this as via media, midway, right? Where they both seem to be complementary to each other. Fine. There's an exam called CLAT. If you've heard of CLAT, right? In CLAT, they ask judicial reasoning. Fine. So there's no wonder maybe over a span of time in UPSC also they'll start asking reasoning questions, constitutional reasoning, right? Like you have judicial reasoning, the geographical reasoning, environmental reasoning. वो reasoning based questions पूछने लगेंगे. Because after that point of time they'll exhaust the facts. How many facts they'll ask? So they'll start asking the reasoning. That okay, this is the provision of the constitution and this is a particular example. Now reason. What do you infer from this example? Right? So time obviously analysis has to be used, right? So this establishes the somewhere the sanctity of both. One should not dominate the other, but in terms of any conflict, the FR will prevail. Fine, that is clear. Fine. Now, so you write some questions on this idea: FR, DPSP, FD. Okay, right. Consider the following. Consider the following. Number one. Okay. In case of conflict between FR and DPSP, the final interpretation rests with the courts. FR and DPSP are complementary to each other. To promote cottage industries, cooperatives, local governments are socialistic principles of DPSP. The provision for 43B was added to Part 4 by Part 4 by 93rd Constitutional Amendment Act. Fine. Which is our incorrect. One, just read and tell me.
C is incorrect because it comes under Gandhian principles. So the next thing is D.
Cottage industry, Gandhian. Cooperatives be Gandhian hai. Even though, see, try to understand, there is no classification in the Constitution. So are they socialistic or not? So कैसे incorrect है? But in DPSP there is no classification. No? So Gandhian भी socialistic हो सकता है, socialistic भी Gandhian हो सकता है. By local government भी तो एक socialistic principle ही है. Power to the community. Fine. So if you take the standard practice in the books, so we can say कि भाई this is Gandhian, right? But as the Constitution itself does not make any distinction, right? So this will not seem to be correct, right? UPSC will make a standard statement not based on the assumption, because when you take Constitution as such, फिर वहां पे तो कोई classification है नहीं, ठीक है? तो ये गलत नहीं मान सकते, fine? It has to be correct, right? In case of conflict between FR and DPSP, the final interpretation rests with the courts. ये settled है या interpretation का? See, it is settled law. What is a settled law? That's something which has been established, right? First, but see, this statement is not wrong. क्यों? वो settled law भी किसने interpret किया है? So when you generalize the statement, it is correct. Fine, understanding? So judicial interpretation है, no doubt, right? When you talk about privacy or Aadhaar, and then Supreme Court again reinterprets कि भाई privacy or Aadhaar must be subject to the privacy or the principle of individual privacy or individual fundamental right implied under this. तो court interpret तो करता ही था. That cannot be eliminated, right? So this is correct. Interpretation rests with the courts, no doubt. Though there is a settled law. What is a settled law? कि 39B and C 14 और 19 को violate नहीं कर सकता. Rest fundamental rights will have privacy over. But ये correct. Right. FRDPSP are completely ठीक है. The provision for 43B was added to the Part 4 by 93rd Constitutional Amendment Act. 43B is cooperatives. And kindly write it kindly. You'll remember. 43B cooperatives. And this was by 97th Constitutional Amendment Act 2000. Correct, Priyanshu bhai? So 43B is cooperatives, fine, and it was added by 97th Constitutional Amendment Act. 51A, yesterday we talked about what is 51A. Right, 51 security, correct. 39A free relegation, yes, right. So you should remember this only, you can remember, right? Okay. So correct answer क्या है? सिर्फ right. Next लिखो. Assertion. FR are justiciable and impinge a negative obligation whereas DPSP are not justiciable but impinge upon the state positive obligations. Reasoning, right? Any liberal democracy needs to give primacy to the individual rights than collective interest. Fine. What should be the answer? You know the usual. A क्या है, B क्या है, C क्या है, D क्या है. Right? Both are true, and R is the correct explanation of A. Both A and B are individually true. A is true, R is false. A is false, R is true. Now you read it properly. A is correct. First thing you have to do is to find out whether both are correct or not. Both are correct. So what is the answer? Both are correct. So answer क्या लिखूं?
These are reasoning for A.
Very good. You just see FR are justiciable and impinge upon a negative obligation on the state, whereas DPSP are not justiciable and impinge upon the state positive obligation. Right? अब ये तो एक बोल रहे हैं कि भाई somewhere FR negative है, that means it is restriction on the government, and DPSC is more about progressive, right, or some direction on the government. ठीक है, ये तो ठीक है, लेकिन ये नेगेटिव क्यों है और ये पॉजिटिव क्यों है? रीजन तो इसका चाहिए ना भाई. तो वो रीजन क्या है? Any liberal democracy needs to give primacy to individual rights than collective interests, right? This reason is correct? Yes. When we say liberal democracy, we want the state to protect our rights. So we are a liberal democracy, not Western type. Fine? But we are a liberal democracy of our own type, right? So answer क्या होगा? See? A should be answer, not B. It seems कि B is answer लिखा श्री, but no, it is A. Liberal democracy has to give, and that is why we have fundamental right, and it is a restriction on the state. That is how the balance between DPSP and अगर हम लिखते हैं welfare state है, तो ये reasoning सही नहीं होता.
Basically, the first solution is talking about the fundamental right as supreme. So
Relation between them.
If you see, it wouldn't be equal partially.
अगर welfares के ऊपर है individual rights, individual liberty dominates the welfare. हम ये बोल रहे हैं. क्यों ऐसा है? क्योंकि हम एक लिबरल डेमोक्रेसी है. सिंपल सी बात. फाइन. लेकिन अगर हम लिखे हम वेलफेयरिस्टिक हैं, तो फिर तो द कलेक्टिव इंटरेस्ट वुड हैव डोमिनेटेड द इंडिविजुअल राइट्स. दैट वुड नॉट हैव बीन अ करेक्ट एक्सप्लेनेशन. अगर हम लिखते हैं कि डीपीएसपीज आर गाइडेंस फंडामेंटल टू द गवर्नेंस ऑफ द कंट्री, यस, एंड इट इंपोजेस वेलफेयर ऑब्लिगेशंस ऑन द स्टेट, करेक्ट, एंड देन वो बोलता है कि हाँ, इंडिया इज अ वेलफेयर स्टेट, एक्सेप्टेबल. Every reasoning has to be understood in the context of the assertion. It should not be generalized all the time. क्योंकि generalize करने पे तो इंडिया वेलफेयर भी है और लिबरल डेमोक्रेसी भी है. But the reasoning has to be in context of the assertion. No, that is why the reasoning has been put. Fine. तो reasoning individually correct हो, right? और जिस context में हम उसको use कर रहे हैं उसमें वो fix हो जाए, तब वो correct है. Otherwise, this can be correct. This can be correct, but this may not be in the context of this.
Reasoning में liberal democracy that individual rights to be protected.
That is democracy, liberal democracy.
So अगर first justiciable है तो individual का
Protect हो रहा है.
वो protect हो रहा है, तो इसमें तो liberal democracy तो फायदा है ना.
अरे तभी तो लिख रहे हैं हम लोग कि भाई ये नेगेटिव ऑब्लिगेशंस हैं, तो ये नेगेटिव क्यों हैं, ये स्टेट को क्यों कंट्रोल कर रहे हैं और ये नहीं, क्यों ऐसा हो रहा है? क्योंकि हम ये हैं. ठीक है. अपोजिट कर दो. इफ यू अपोज इट, नो, इफ यू मेक द रीजनिंग assertion, yes, बिल्कुल हो सकता है. बट लिबरल डेमोक्रेसी भी एक रीजन है ना कि हम लिबरल डेमोक्रेसी हैं. दैट इज व्हाई वी हैव टू गिव द इंडिविजुअल, प्रोटेक्ट द इंडिविजुअल लिबर्टी. राइट. तो पहले हम लिबरल डेमोक्रेसी है ना भाई, दैट इज द फिलोसफिकल बेसिस, देन ओनली वी क्रिएट अ सिस्टम. ठीक है, इसलिए हमने इसको रीजन लिया कि हमने पहले ये फिलोसफिकल प्रीमाइस क्रिएट किया. First we believed in this philosophy, then we went to this system, right? So we are assuming that this has come first and then this has come. Are you saying? So this is a consequence of that, right? That is why it is taken as reasoning. Fine. Next, likho bhai. Consider. In Golaknath case, 1967, the Supreme Court declared the fundamental rights being transcendental in nature and cannot be amended. Cannot be amended. Articles 350A, 351, 335 are welfare principles or welfare provisions. Welfare provisions beyond PPSP. See. Article 50 establishes the separation of power principle in the D. '25th Constitutional Amendment Act 1971 provided for the primacy of certain DPSPs over FR certain DPSPs over FR being immune from judicial review. Fine. See. So which of these now tell the answer. Only ANC, only AND, only C, none. Incorrect. Priyanshu, भैया बताओ. First statement. Transcendental in nature, correct. Fine. So they cannot be amended. That was the idea. फिर केशवंत भारती में चेंज हो गया. Right. Articles 350A, 351, 335, etc. are welfare provisions beyond DPSP. What is 358A? 350A? क्या है? Reservation of seats for SCs, STs in legislatures. Fine. Protection of linguistic minorities, how? By providing the office of a commissioner or linguistic commissioner. तो 350A और 350B, A में मदर टंग में इंस्ट्रक्शंस होगा लिंग्विस्टिक माइनॉरिटीज को, और 350B में a commissioner for linguistic minorities can be established, appointed by the President of India. So you can add B also. Commissioner for linguistic, office of the Commissioner for linguistic minorities, instructions in mother tongue, right? 351, promotion of Hindi language, right? Not mandatory, right? So 351 is that state shall take steps to promote Hindi language so as to preserve the composite culture of this nation. So 351 ये है, 335 ये है, 350A and B ये है, ये सही है. क्यों? These are also for welfare measures. Some people may object to this, but this is not correct because it is for promoting the common culture, not for promoting a particular language. Right? Because majority of the people speak it, so that can be used as a ground to integrate people. Purpose वो है provision का. Fine. Politics कुछ और बोल सकती है. Right? Article 50 establishes the separation of power principle in the context of India. Both this statement can be interpreted in both ways. Because it is non-justiciable, it does not establish the separation of power principle. क्योंकि non-justiciable है. Right? But yes, it does talk about separation of legislative executive from judiciary. Fine. So now it is highly subjective. कि एक point of view से ये सही है, अलग point of view से गलत है. Because separation of power would mean separation of executive, legislature, judiciary. That is the doctrine. Fine. In context of USA. तो अगर हम ये बोले कि separation of power principle may not be correct, right? If it says separation of power between executive and judiciary, फिर तो ठीक है. और separation of power in a limited manner between executive and judiciary. तो क्या establish करता है ये principle? नहीं. Right? क्योंकि as a philosophy, as a principle, हम उसको follow नहीं करते हैं. We do not have exact separation of power, right? We have division of power, we have distribution of power, but we do not have as a philosophy separation of power, right? Because executive and legislature are both integrated together. It is a parliamentary system, right? So if it was a presidential system, then it would be possible, right? So we cannot take this as absolutely correct, even though ये पूरा incorrect नहीं है, fine? So we may take it as incorrect. क्योंकि किसी ऑप्शन में अगर दिया है तो we have to give that concession, right? क्यों पूछती, पीछे पेपर किया पिछला की नहीं, प्रीलिम्स दिया ना, सो देख लो उसमें क्या क्या उसने पूछा. बिल्कुल पूछता है. सी दैट इज व्हाई 5-10 आंसर्स जो है हमेशा दे विल बी नॉट क्लियर. सी मोस्ट ऑफ देम द आंसर कीज व्हिच आर रिलीज्ड, okay, they have lot of doubtful questions. 20-25 answers are not correct. Many of these institutes which release the, why, that is the reason. If you take the answer on the face value, right, तो आप आंसर दे देते हो, लेकिन यूपीएससी उसको फेस वैल्यू पे नहीं लेता, फिर वो उसको मोल्ड कर देता है. Right? It has happened many times. And you know that is an instruction. UPSC का जो स्पेशल गाइडलाइन है कि जब भी ट्रांसलेशन होगा, एनसीईआरटी की गाइडलाइन है, सीबीएसई की गाइडलाइन है हर एग्जाम के लिए, कि whenever there will be an issue in translation, then the English version will prevail over any other translation. That is also one reason. That the kind of word they are using when you are giving a polity statement, right? It is not merely a vocabulary; it is a specific vocabulary, which has been used with context of polity, not the context of environment. Understand? Environmental concept of being organic, right? वो तो polity का ही concept होगा. See, so you have to interpret the statement in that way. So when we are saying separation of power, right? तो absolute है नहीं, right? Justiciable है वो भी नहीं है. तो कैसे principle establish हुआ? It's not established principle, no, right? Though we talk about here separation of executive from judiciary, but it is a DPSP. That means it may or may not happen. So how do we interpret? Now when we see the option, and in the option it is given कि हाँ, if I have a dilemma, they have already given the option, right? और एक option क्या दिया है? Only C. इसका मतलब पूछने वाला भी बहुत specific है, right? अगर सिर्फ ऐसा option नहीं दिया जाता, then you could have said कि हाँ fine, I can take the benefit of doubt and go ahead with this. ठीक है? लेकिन अगर option दिया हुआ है, so that means they are aware कि you might be confused here, right? 25th Constitutional Amendment Act provided for the primacy of certain DPSPs over FR 1419 being immune from judicial review. That is also correct. Yes. Basically for 39B and C. Fine. Now, so answer क्या है? Right. Fine. So जो DPSPs हैं और FDs हैं और FR हैं भाई, majority of the question जो है वो इसके अराउंड डिजाइन होते हैं. Conceptual principles, constitutionalism, political system, right? एक मेजर पोर्शन है जहां पे क्वेश्चन डिजाइन होते हैं बेसिकली पार्लियामेंट, parliamentary system, right? Role of speaker, president, governor, right? These kind of questions, they are quite, what you can say, usual in UPSC because a lot of complication can be done there. Fine. So let us see. कुछ doctrines हम पढ़ चुके हैं. So कुछ doctrines मैं बताता हूँ, then we'll talk about that. Fine. They have been asking questions on doctrines also. This is right. We have talked about many doctrines. What doctrines we have talked about? Correct. Okay. Construction. Okay. Fine. Doctrine of severability. Tell me specific thing.
Which is unnecessary.
Post constitutional law. ठीक है, पहले बेसिक चीज इसलिए याद होना चाहिए, right? So, doctrine of severability. तो स्पेसिफिक क्या है? पोस्ट कॉन्स्टिट्यूशनल लॉज. That part is severed which is void fine. The way it is severed should not create the problem for the implementation of rest of the law. ये भी एक ground है. See? So when you are severing it, right, or when you are eliminating it, the other part must remain functional, right? If the other part does not remain functional, try to understand. If the other part had a dependence, or the rest of the part which is left had dependence on the part which has been severed, then what will happen? Then the entire law will be declared as unconstitutional. Fine, because then it cannot be operational. But court बोलता है as far as possible, try to make it operational. Right? या तो पूरा लॉ रीइनैक्ट होगा. ठीक है, सिर्फ वो पार्ट जो हट गया है अगर उसको मॉडिफाई किया जा सकता है तो वो भी मॉडिफाई हो जाएगा. Right? But see, that is the idea why it has been done, so that doctrine of eclipse can be applied for 13.1, this can be applied for 13. Right? Doctrine of eclipse. This is, it is merely a shadow. Right? Law is not abrogated as such. Correct? Pre-constitutional. As such, pre-constitutional laws, then now, how this shadow is removed? The moment any judicial judgment comes, right? Any new law is made which somewhere accepts the previous law or the eclipsed law as legal. That very moment the eclipse goes away. There is no need for a separate legislation or a separate amendment or any other action to make this eclipse go away, right? तो ये eclipse कैसे जाता है? Automatic है. This additional law तो हम we are trying to abrogate. but there is no technically replacement. No? So basically, there are so many other provisions or so many acts which cannot be put under any other provision. So sedition क्योंकि defined नहीं है, right? Sedition is purely discretionary in nature, right? Sedition is basically a colonial legacy. Post independence में उसका कोई use नहीं था, right? So that is a problem. But we'll talk about it, right? So ये automatically eclipse खत्म हो जाता है, right? It is for 13, right? Or for laws in force. Fine. Then doctrine of waiver, maybe that you know. There was a question given. There was a question given in the test. Huh? So obviously, waiver or doctrine of waiver, USA, you can waive. India, you cannot. Right? Can it be waived by a public policy? Right? So can the ground of DPSP be taken? Can the ground of public policy be taken to waive or exclude someone from the benefit of fundamental rights? Nahi kiya sakta, right? So it cannot be done as a matter of public policy, that is by the state. Can it be waived by an individual himself? No. Because this will create a ground for the government to use it for so many other things. So even if an individual wants to waive his fundamental right, he cannot waive his fundamental right. Right? If he says, accepts in front of the court that, okay, see, Lekhashi, with respect to the context of India's separation would mean no. Separation of power is a principle. It has nothing to do with context of a country. Right? So when you say what is separation of power means that three organs of the state are relatively independent of each other. Right? You cannot say that rule of law in the context of India means this. Yeah. So we can say that we do not have exact principle which we are using, right? Even though we have tried to use it or we have tried to enforce it as far as possible. Right? So we cannot say as a philosophy we have followed it in letter and spirit. Right? But हम उसको deny भी नहीं कर रहे, क्योंकि fundamental right में होना चाहिए separation of executive from judiciary. If it was so, then it would have been easy for the citizen, right? Quasi-judicial bodies, administrative tribunals, variety of other regulatory bodies, they are giving the judgments and they are enforceable, right? लेकिन अगर वो होता तो भी problem होती, why? You could not have created regulatory bodies. It was impossible for you to create quasi-judicial bodies. It was impossible for you to create special courts and this, because then it was not possible, right? So हमारे यहाँ तो बिल्कुल भी separation of power principle follow नहीं होता है, right? Judge is appointed by judges, but removed by legislature. Fine. So drawback, see. Ultimately, the mercy petition is to be heard by or clemency petition is to be heard by the president. तो कोर्ट का पावर भी, कोर्ट का काम भी एग्जीक्यूटिव कर रही है, right? Executive का काम भी कोर्ट कर रही है, PIL, judicial review. So we cannot say कि we follow this as a principle, right? But obviously we don't want to violate it. हमारे पास भी mechanisms हैं. So the moment you say we do not follow absolute separation of power, means what? We do not follow the philosophy of the separation of power. Here and there we have provisions for it. That is correct, right? Now see, let us imply. So if waiver, now is waiver guaranteed in the Constitution? No, that's a judicial doctrine, right? So क्या ये constitutional obligation है कि you cannot waive your rights? No, right? So it's a judicial doctrine. Yes, judicial reviews. In various judgments, the judiciary comes with the ideas. Just the Olga Telly's case we have talked about. Fine.
So, like recently in Punjab, for my mother election, this district officer who have done that,
Who was manipulated? Huh?
that politics. How can we in these doctrines, how which doctrine will be
In which sense? No, in which sense? That is what I'm asking. No? which sense we want to use the doctrine. But doctrine is a very broad premise, right? Under a doctrine, many of the judgments can be taken, many decisions can be taken. So doctrine is more of a moral and legal framework within which we operate, right? Understand? Doctrine kya karta hai? It creates a kind of system, a process under which we have to operate. So judicial doctrine is much more than a law in that sense. Understanding? It is like an established philosophy of judiciary. So anything which violates it, right, will be taken as violation of the constitution. Kyunki doctrines bane kaise? Interpretation of the constitution.
We are considered that it is a violation of the law. That we have done. So to directly take that case, like that incident.
See, somebody has complained, right?
Somebody
Opposition members complained. Fine. Then obviously the court will ask for evidence. The evidence was present. So obviously that is a direct case of violation of one's integrity, right? Election हो रहा है, model code of conduct है, उसकी एक ethical responsibility भी है, सिर्फ legal नहीं है. Right? So there are numerous doctrines which judiciary can invoke, right? So it is up to, see, it is up to not necessarily a specific situation will come under a specific doctrine. Understand it? Many situations or one situation may come under multiple doctrines. Right? तो ये नहीं कि एक situation में सिर्फ एक ही doctrine apply होगा. Doctrine is, you can understand the philosophical premise. These are the lenses, these are the specs through which the judiciary sees and thinks. You can understand this way.
The torture liability can be taken. Torture liability. Like will state defend behalf of him.
See, tortious liabilities is civil wrongdoing, right? State is not directly doing anything.
But administratively,
So he is working on behalf of Election Commission, no?
but is an administrative.
Oh, that's correct, but he's working on behalf of Election Commission. So what administrative action is that? First we have to define it, no? What kind of administrative action is that? Malfeasance, overfeasance, misfeasance, error of jurisdiction, crossing of jurisdiction, discretionary, कौन सा act है? पहले डिफाइन करना पड़ेगा ना किस टाइप का एक्ट है, राइट? तो करप्शन के अंदर आता कि नहीं डेफिनेशन के अंदर, राइट? वायलेशन ऑफ कोड ऑफ कंडक्ट है, क्या है? यू हैव टू डिफाइन इट फर्स्ट, right? Then only you will file a case. Okay, by these provisions of the Central Civil Services Conduct Rules, Election Commission of India Act, or the Representation of People's Act, ye provisions are there in which this person has violated it. Then we'll talk about it. Right? So first you have to define exactly what is the nature of act. Right? तो outrightly corruption कर रहा है भाई. Misuse of public authority, understanding? That is a corruption. Right? So waiver is a judicial doctrine. Fine. Then the rest. Eclipse we have done. Okay. This doctrine of territorial nexus क्या है? चलो फोर्थ जो हमने किया हुआ, चलो let's write first doctrine of let's write first doctrine of stare decisis. Fine. Doctrine of stare decisis. Then we'll talk about this. What is it? See, this says, this talks about precedents. How do courts work? Right? अभी एक judicial doctrine है जो judicial या judicial actions के लिए बना है, judgments के लिए बना है, right? See, the philosophy of the principles that judiciary follows when the judgments are given. So, stare decisis means doctrine of precedents. Precedents means that in a particular type of case, right, in a particular type of situation, if the court has already given a judgment, right, that is why we say court will review its judgment, right? Or a similar case approaches the court again, then the judgment of the previous court or previous judgment, sorry, of the court must have sync with the latest judgment of the court. Understand it? So if there is a kind of observation and acceptance of precedents, right? So a sync between the previous and the latest. In a similar issue, if the court has talked about something on privacy, try to understand, right? And thus again this issue has been taken up, then court will try to create a continuity between this and this, or maintain a coherence between this judgment and this judgment, right? Unless it totally overrules this judgment. Understand?
In this doctrine, will
It will not try. Normally, it does not try to overrule it. That is what the doctrine says. So, what is the general principle that judiciary follows? High courts, Supreme Courts, any court, that they try to maintain parity or continuity with the previous view, right? And if there is a difference in the view, then obviously there will be reviews by the court itself. By how come today's judge is viewing the same issue from a totally different perspective than the evaluated by the previous judge? Right? This will raise the doubt on the trust or the trust of the people on the courts. Right? Judiciary itself will not be able to establish a common principle on which it will work. ठीक है? इसलिए बोला जाता है कि भाई जुडिशरी जो है वो प्रोसीजर एस्टैब्लिश्ड बाय लॉ से चलती है. We are a procedural system. Why we are a procedural system? Because of that only. That as we follow the procedures, right, then more or less the outcomes will become similar. So to maintain the continuity, to maintain the integrity of the previous judgment, to maintain the sync of the latest judgment with the previous judgment, the court follows or judiciary follows this principle, right? This principle may not be applicable to tribunals, you understand? So ये applicable है to judiciary. सबको. जुडिशरी मींस द एंटायर जुडिशरी. सुप्रीम कोर्ट डॉक्ट्रिन फॉलो कर रहा है, लोअर कोर्ट कैसे फॉलो नहीं करेगा? करना ही पड़ेगा उसको. See, very interesting idea. Now, when you say that we are a procedure established by law system, right? We follow the rule of law. So when we follow the rule of law system, what has happened? We have established certain principles already. तभी तो हम follow कर रहे हैं, right? अब जैसे हमने बोला कि this will not be directly applicable to tribunals or quasi-judicial bodies. They are not bound by this doctrine. What do we mean, right? That we are not bound by, or they are not bound by following first the similar procedure, right, in every judgment. Similar procedure even in the issue which has already been tackled by them. Right? Their basis of evaluation may change. So tribunals, administrative tribunals, quasi-judicial bodies, ये क्या follow करते हैं? अब see, it is also rule of law, right? Don't be confused. But they, or we say they follow the principle of natural justice. Why are we trying to distinguish this natural justice with the rule of law? The rule of law is more traditional type of principle, right? It establishes a kind of rigidity, something fixed. That is rule of law. तो rule of law के fixed premises हैं, right? Principle of natural justice जो है उतना procedural नहीं है. It talks about philosophy, not the procedures. You understand? So when you use the word principles of natural justice, it means that we follow certain principles, right? But procedures are not to be followed as such, or there is no fixed procedure to be followed. Whereas procedure established by law says what is the procedure that has been established will be followed. So administrative tribunals, quasi-judicial bodies, they have flexibility in operation. And that is why they need not be bound by the procedure. Fine? You understand? This is a very important difference. क्यों ऐसा होता है? See, because the nature of functioning of these, or they have been created to reduce the burden on the judiciary. If they will also be bound by the procedural complexity as the judiciary is, then their purpose is no more valid. Then why are they created? So they have to maintain flexibility in their operation. And for that purpose, they are not bound by the procedural complexities. They can modify. Understand? They can, obviously within the law in which they have been created, right? So under the parent law or the act or the statute under which they have been formed, they can modify their procedures themselves. Right? Obviously not violating the law. Understand? So they will not violate the law, but they can modify their own procedures. They can waive certain procedures. They may say, no, you don't need to follow this procedure, it's okay. You come without this procedure, you understand? As a courts में बोला जाता है कि you cannot bring the witness without giving opportunity to the opposite party, without telling them. But it is up to the judge who can allow or not allow. See? So generally, judiciary is governed by procedures for everything, right? Whereas these quasi-judicial bodies, tribunals, they are not bound by it. तो जितने भी जो criminal type courts है ना, जो criminal justice देते हैं, they have to be bound by procedure. They cannot violate or negate the procedure. Understand? And that is why there is a debate about the preventive detention laws. because they are basically violating the procedures, or they are giving special procedures or special powers to the executive. Right? So, natural justice now. So, when we use ki bhai, is the doctrine of precedent applicable to these bodies? No. Why? Because they are not bound by procedural complications. Why judiciary is bound? Because it has to follow the coherence, right, between its judgments. Right? Every judicial level has to be in sync with the other level. So, doctrine of precedent not applicable to the quasi-judicial body or other bodies, right? Applicable to the judicial. Fine. Judicial or tribunals are governed by their own procedures. Just NGT Act hai, it's governed by its own procedures. Fine. But that does not mean they violate the rule of law, right? It simply means that they have flexibility in operation. Right? Now, this is what fourth. Doctrine of colorable legislation. Right? So you cannot manipulate it, you can write. कहाँ जैसे ये मिसयूज हो सकता है? For example, let us say you have Article 246, 245, 246. This deals with what? This deals with the legislative relation between union and state. In this sense, you have three lists. So union state concurrent, you have three lists, right? Now, if the union says that we want to bring this particular provision from state to the concurrent, forest, wildlife, education, right? It's a wire. So obviously there was a purpose for that. That's okay, right? But just a CRPC, IPC already hai concurrent list mein. Ya dono list mein, you can imagine this way, right? So if the union tries to do this, right, and somehow it wants to take away the powers. For example, just उसने local government में changes किए amendments किए, right? As model code, model police act was made by the central government. ठीक है? 2006 में 2005-6 में मॉडल पुलिस एक्ट बना. वो पुलिस एक्ट जो है स्टेट के कंट्रोल में होना चाहिए, यूनियन के नहीं. हाउ कैन यूनियन गवर्नमेंट फ्रेम अ मॉडल पुलिस रिफॉर्म एक्ट, राइट, एंड एनफोर्स ऑन द स्टेट्स? दैट इट कैन नॉट डू. सो मेनी टाइम्स ऑन सर्टेन ग्राउंड्स, अभी जैसे दिल्ली का केस है, GNCTD जो केस है 2018 का, राइट? सो अब दिल्ली का केस है, that governor, lieutenant governor has taken up all the powers. Services were brought under the union government or under the LG directly. It is already there. Fine. So why this was done? So if there is no explicit reason, तो ये assume किया जाएगा कि भाई this was done primarily to reduce the power of the state. So doctrine of colorable legislation applies to those things where, right, it is assumed that certain decisions or policies or laws would have been made with some with some implicit purpose. So it is visible something, but there is something which is being done, right? You write few lines on this. Right. Right. Many times, okay, the legislatures, both at union and state, make laws that are beyond their legislative competence or do not fall under their respective list. Okay. The idea is that what you cannot do directly, you cannot do it indirectly. What you cannot do directly, you cannot do it indirectly. It applies to both. both the technicalities of the procedure and but also to the substance of the law. Right? It also includes the language of the law, the procedural competence, and also the intent behind the law. Though the primary test would be procedural / jurisdictional competence. So, that is, intent will not be the first, intent last में evaluate होगा, समझ गए? पहले the technicalities will be evaluated. If something fails on the ground of technicality, then it has failed already. Understanding? Whatever is the intent, उससे कोई फर्क नहीं पड़ेगा. ठीक है, अब सी सो इवन तो पहला टेस्ट क्या है, सिंपल, कि भाई टेक्निकल कॉम्पिटेंस है कि नहीं, whether the procedures were followed or not. If they were not followed, khatam. What was the law, what was the purpose, what was the substance, what is ethics and morality comes later on. तो bona fide था, mala fide था, intent क्या था, ये बात की बात है, right? So primarily there will be no reason to evaluate the intent if technically the law is wrong, if the procedure was not correct. तो पहली law गलत हो गया, see. It applies to both state, right? It also applies to the interpretation of the list, right? For example, if you are bringing education in the concurrent list, right? Then what aspect of education? ये भी एक interpretation है. Higher education कौन देखेगा? Higher education state भी देखेगा, union भी देखेगा, right? Primary education state भी देखेगा, union भी देखेगा. Now see, again, when you brought education in the concurrent list, right? But there is also a provision for the local governments to run educational institution. Where will that come into competence? Understanding? So it evaluates everything, whether the state government has the power to make a law on the education or educational institution which falls under the local government, right? Or whether the law made by the union government, right, will be applicable to the state in a particular way. Fine. So there are so many areas of conflict between union, state, local, and various other bodies, right? I'll just say AICT, UGC, they have been given some powers to make laws with respect to their domain, or at least we can say rules, regulations, provisions. Fine. If they do it in any way where it seems to restrict the powers and functions of a state level body, right, then it will be reviewed. But you have role in education, but is your competence or sphere of competence, is it encroaching upon the other sphere of competence? Have you made this law? तो पहले तो law वैसे ही गलत हो जाएगा. If the procedure is followed correctly, if they have a competence to make the law, then the second test will come, right? कि भाई क्या nature है law का, language क्या है, what is the intent क्या है, then you will evaluate, right? Prima facie, if procedure is wrong, then it is wrong, right? Then there is doctrine of pith and substance. What is that? What is pith and substance? Lekashri, anyone? Pith and substance. You are writing. Let us say you are writing so much. Fine. अब आपने इतना सारा लिखा, right? Ultimately आपने conclusion लिख दिया. Fine.
Introducing the Prelims Target course and Prelims Test Series at ProdEgyIAS. Designed for UPSC Prelims 2026, this comprehensive program offers in-depth classes on history, geography, science and tech, environment, polity and governance, and economy. Stay updated with current affairs and sharpen your skills with our Prelims Test Series consisting of 50 full-length tests covering all subjects along with CSAT. Join ProdEgyIAS and stay ahead.